Today, I will present a case that highlights the importance of knowing your employment rights in Canada. This case, FAM versus Qualified Metal Fabricators Limited, which is actually a recent one. In this case, we'll discuss what the employer did wrong, what law was violated, and the rights of employees when it comes to layoffs. So, what exactly did Qualified Metal Fabricators do wrong in this case? It all comes down to how they handled Mr. Pham's layoff during the COVID-19 pandemic. Pham, along with other 30 employees, was informed in March 2020 that he was being temporarily laid off, and the layoff was extended multiple times. Now, you might think, well, isn't that how things went during the pandemic? Here's where the issue lies. In Canadian employment law, layoffs aren't just something employers can decide to do whenever they want. There has to be a specific term in an employee's contract that explicitly allows for layoffs, or there has to be an implied understanding between the employer and the employee. In this case, there was neither. Qualified metal fabricators had a past practice of laying off employees, including a layoff in 2009. But here's the kicker. Past practices don't automatically give employers the right to lay off employees in the future. Each layoff must be either explicitly mentioned in the employment contract or agreed upon by both parties. Pam's contract has no such term, meaning that his layoff amounted to what's called constructive dismissal. In simpler terms, by laying him off without his consent or contractual agreement, the company essentially terminated his employment. In terms of the legal side, the case centers around the violation of common law principles, specifically the concept of constructive dismissal. In Canada, when an employer makes significant changes to the employee's contract without consent, like a layoff without the proper contractual basis, it can be seen as forcing the employee to resign. The employer can't just rely on the practice or the past practice to justify it. This was a key point in this case. Now, the big question: what should qualified metal fabricators have done differently to comply with the law? There are two key actions they should have taken. First and foremost, the employer needed to ensure that FAM's employment contract included an explicit clause that allowed for temporary layoffs. This clause should clearly state that the circumstances under which the company could lay off an employee. In the absence of this, any layoff can be seen as breach of contract. Employers can just assume that employees will accept a layoff, even if it's temporary or if it's done in the past. And second, they should have communicated more clearly with FAM about his rights and options during the layoff period. Even though they gave him letters extending the layoff, there was no evidence that FAM agreed to these extensions willingly. In fact, just because he signed the letter doesn't mean he condoned the layoff. In Canadian law, an employee's signature doesn't necessarily mean they accept the change unless it's accompanied by clear consent. In short, they needed to be upfront in the contract and transparent in their communications. So, what could Mr. Pam do legally? Well, the main remedy for him was to pursue a claim for wrongful dismissal. Since the court ruled that the layoff was a form of constructive dismissal, Mr. Pham had the right to seek damages for the loss of his job. Employers need to be careful, as wrongful dismissal can result in significant payouts to employees if they don't follow proper procedure. The big takeaway from FAM versus Qualified Metal Fabricators Limited is employers need to have clear terms in their contracts if they plan to lay off employees, most especially. And for employees, know your rights. If you're laid off without proper notice or contract language, it could count as constructive dismissal.